A Supreme Court ruling just came down that most people are already misunderstanding, and if you rely on social media headlines to understand your constitutional rights, that misunderstanding could cost you dearly. What I'm about to explain isn't political spin. It isn't fear-mongering. It's what the court actually said, what it didn't say, and why this 8-1 decision quietly reshaped how both the First and Second Amendments will be interpreted going forward. If you care about gun rights, free speech, or the growing power of the federal government, you need to understand this case properly, because the public narrative right now is dangerously wrong. Everyone online is claiming the Supreme Court just weakened the Second Amendment, or, on the other side, that it saved gun control laws nationwide. Both sides are oversimplifying the ruling, and that oversimplification hides what this decision really did. It changed the legal test courts must use when deciding constitutional rights cases. That shift matters far more than the headlines. Let's start with the basics. The Supreme Court ruled 8-1 in a case involving firearm restrictions tied to domestic violence restraining orders. Only one justice dissented. That voting breakdown alone should raise eyebrows. This was not a left versus right, conservative versus liberal showdown. When 8 justices across ideological lines agree on a constitutional issue, it usually signals something narrow, technical, and legally precise, rather than a sweeping political statement. But that's not how it's being portrayed online. The ruling did not erase the Second Amendment, it did not create unlimited gun confiscation powers, and it did not announce that constitutional rights depend on modern political preferences. What it did, instead, was far more subtle and more impactful. The court reaffirmed that the government can temporarily restrict firearm possession only under specific procedural and factual conditions, while at the same time redefining how courts should evaluate modern laws against historical constitutional protections. That second part is the real story. One of the biggest mistakes people make when reacting to Supreme Court rulings is ignoring the facts of the case itself. Courts do not rule in the abstract. They rule on real people, real records, and real conduct. In this case, the individual at the center of the ruling wasn't a borderline example or a harmless technical violator. According to the record, the person subject to the restraining order had violated court orders multiple times, threatened others with firearms, been connected to multiple shooting incidents while under court supervision. These were extreme facts, and the court made that clear. The ruling was based on a scenario where a judge had already held a hearing, evaluated evidence, and made explicit findings that the individual posed a credible threat to the physical safety of others. That matters because the court was not deciding whether the government can disarm people casually, automatically, or preemptively. It was deciding whether constitutional rights allow temporary firearm restrictions after due process, when a court finds a demonstrated danger based on evidence. Social media narratives flatten all of this into one misleading claim. Anyone with a restraining order can lose their gun rights. That's simply false. The Supreme Court went out of its way to keep this ruling narrow. It did not bless blanket firearm bans. It did not approve emergency orders issued without hearings. And it did not say states can bypass procedural safeguards. Instead, the court focused on 3 specific elements. Notice, the individual must be informed of the proceedings. Opportunity to be heard, there must be a real hearing, not a rubber stamp, and specific judicial findings. A court must explicitly determine that the person poses a credible threat. Without all 3, the ruling doesn't apply. That distinction is critical because many protective orders issued in family courts across the country do not meet these standards. Emergency or ex parte orders issued without the accused present were not validated by this decision. The court was threading a very narrow needle, balancing individual rights with historical traditions of restricting dangerous conduct, not dangerous opinions or lawful ownership. And that's where the constitutional shift begins. Here's the part almost nobody is talking about. This case didn't just clarify one type of gun restriction. It clarified how courts should evaluate all modern laws that affect constitutional rights, especially under the Second Amendment and increasingly under the First. Until now, lower courts were deeply divided on how to apply recent Supreme Court precedent. Some demanded near-identical historical laws from the 18th century to justify modern regulations. Others accepted broad historical comparisons that made constitutional protections feel flexible to the point of meaninglessness. The Supreme Court stepped in to end that confusion. The court made clear that constitutional analysis does not require a historical twin, an exact copy of a modern law from 1791. What it requires is a historical analog. That distinction changes everything. A historical analog means courts must ask two questions. Why did similar regulations exist historically? How did those regulations burden the right at issue? If a modern law serves a similar purpose and imposes a comparable burden, it may survive constitutional scrutiny, even if it looks different on the surface. This prevents two extremes: treating the Constitution as frozen in the 18th century, treating it as infinitely flexible based on modern preferences. The court explicitly rejected the idea that rights only exist in the exact form they did centuries ago. At the same time, it rejected the idea that governments can invent new restrictions untethered from historical practice. That balance is now the governing rule. Once you understand the historical analog framework, you start to see its reach. This same logic is already being applied to free speech disputes, financial deplatforming cases, government pressure on private companies, association and advocacy rights. The First Amendment implications are coming fast, and they're unavoidable. If courts accept analog-based reasoning for the Second Amendment, they cannot logically reject it for speech, assembly, or association. That's why this ruling matters, even if you don't own a firearm. Most people think restraining orders are private civil matters, relationship disputes handled in family court with limited consequences. That assumption is one of the most dangerous legal myths in America. Here's the reality. A civil restraining order can become the trigger for a federal felony, even when no criminal charges are ever filed. This happens because of a federal statute that has been on the books for decades, but remains largely invisible to the public. Under 18 U.S. Code Section 922 G8, it is illegal to possess a firearm while subject to certain court-issued protective orders. The law does not require a criminal conviction, it does not require a jury, and it does not require proof beyond a reasonable doubt. It requires procedure and language. Federal law activates only when all three of the following elements are present. 1. Notice and opportunity for a hearing. You must have been informed of the proceeding and given a chance to appear and defend yourself. If you ignore the hearing or fail to show up, the order can still be issued and federal consequences still attach. 2. Relationship-based restrictions. The order must restrain you from harassing, stalking, or threatening an intimate partner or child. This definition is broader than many people realize and includes former partners, co-parents, and household members. 3. Explicit firearm language or credible threat findings. Either the order specifically prohibits firearm possession or it includes a judicial finding that you pose a credible threat to physical safety. When those three elements exist simultaneously, firearm possession becomes a federal crime, punishable by up to 10 years in prison. Most people never realize they crossed this line until federal agents are knocking at their door. Family court does not feel like criminal court. There's no prosecutor seated at the table. There's no jury box. The environment feels informal, procedural, and temporary. That atmosphere is deceptive. Judges in family court are trained to err on the side of caution. Ambiguous evidence is often interpreted as potential danger. Vague language becomes standardized order text, and defendants frequently appear without counsel, believing the matter is minor or short-lived. Meanwhile, federal law is watching quietly from the sidelines. Once the order is signed, federal jurisdiction attaches automatically. There is no warning label, there's no separate notice explaining the criminal implications, and there is no grace period to figure things out. Ignorance of federal law is not a defense. Contrary to popular belief, federal firearm prohibitions tied to restraining orders are actively enforced. Federal agencies investigate thousands of cases annually involving prohibited persons in possession of firearms. Many of these cases originate from traffic stops, domestic disturbance calls, social media posts, or financial or licensing background checks. Once firearm possession is discovered, intent becomes irrelevant. You don't need to threaten anyone. You don't need to use the weapon. Mere possession is enough. That's why misunderstanding this Supreme Court ruling is so dangerous. People assume the court just expanded government power. In reality, it clarified an existing system that has been catching people off guard for years.
Now let's talk about the connection almost nobody sees coming. The Supreme Court is currently confronting another constitutional question that mirrors this case in structure, if not in subject matter: whether the government can pressure private entities to suppress constitutionally protected activity without issuing direct orders. In a pending First Amendment case, the court is examining whether government officials violated free speech rights by coordinating with private companies, especially social media platforms, to restrict lawful expression. The legal theory is simple but powerful. If the government can't do something directly, it also can't do it indirectly through coercion. That same theory is now being applied to gun rights, financial access, and association. One of the most effective modern tools for suppressing constitutionally protected activity is financial exclusion. Instead of banning speech or ownership outright, institutions make participation impossible by cutting off access to basic infrastructure. Here's how it works in practice. Advocacy groups need payment processors to collect donations. Businesses need banking relationships to operate. Manufacturers need insurance to function. When those services disappear, the activity effectively dies, even if it remains technically legal. Firearms-related businesses and organizations have experienced this pattern for years. Banks decline accounts without explanation. Payment processors terminate services based on internal risk policies. Insurers quietly withdraw coverage. No law is broken, no regulation is cited, yet lawful commerce becomes unsustainable. Defenders of this system argue that private companies have the right to choose their clients. That's true until government pressure enters the picture. Regulatory agencies issue guidance. Politicians make public threats about oversight. Investigations are launched. Risk assessments suddenly change. This creates a climate where private companies act not out of independent judgment, but out of fear of government retaliation. Courts are now being asked to decide whether that kind of pressure turns private action into state action, and whether constitutional protections apply when the government hides behind intermediaries. The Supreme Court's recent ruling signals that historical analogues will matter here too. If historical governments were prohibited from suppressing speech or disarming citizens through indirect means, modern governments may be bound by the same principle, even if the tools look different. This framework doesn't automatically favor gun owners or government regulators, it restrains both. Governments gain clearer authority to regulate genuinely dangerous conduct, but they lose the ability to stretch constitutional limits through vague standards or procedural shortcuts. Advocacy groups gain stronger protections against indirect suppression, but they must anchor their arguments in historical practice, not modern outrage. This ruling didn't pick a winner, it reset the battlefield. Before we move on, you need to understand the most common mistakes that destroy people's lives in this system. Mistake 1: treating restraining orders as temporary drama. Failing to appear at hearings, ignoring paperwork, or assuming things will resolve themselves often results in default findings that trigger federal law. Mistake 2: posting emotionally charged statements online. Angry posts, vague threats, or frustrated messages are routinely introduced as evidence of danger, even when no harm occurs. Mistake 3: assuming civil proceedings don't affect constitutional rights. Civil court orders can restrict constitutional rights just as effectively as criminal convictions, sometimes more quietly. These mistakes aren't made by criminals, they're made by people who didn't understand the system they were stepping into. The Supreme Court didn't close the book with this ruling, it opened a new chapter. Lower courts now have marching orders, litigants are adjusting strategies, government agencies are reassessing enforcement boundaries, and future cases involving speech, firearms, and association will be decided under this clarified constitutional framework. In the final section, I'm going to explain what this means for the future, how courts will apply this test going forward, and, most importantly, what you can do right now to protect yourself. The most important thing to understand about this Supreme Court decision is that it didn't resolve a single debate, it set the rules for all the debates that come next. By reaffirming the historical analog standard, the court told lower courts something they had been avoiding for years. Constitutional analysis requires real work. Judges can no longer pick outcomes first and search history afterward. They must engage directly with how rights were understood, regulated, and balanced across different periods of American history.
That changes how every major constitutional case will be argued going forward. Under this framework, courts must now answer two core questions in every case involving the Second Amendment and, increasingly, the First. First, what problem was the government trying to address? Was it preventing violence, preserving public order, or regulating dangerous conduct? Second, how severe is the burden on the right? Does the law temporarily restrict behavior, or does it eliminate the right altogether? If a modern law addresses a problem that governments historically regulated, and if the burden it imposes is comparable in scope and duration, it stands a chance of surviving constitutional scrutiny. This is where future litigation will be won or lost. Hundreds of cases are already working their way through the courts, involving magazine capacity limits, assault weapon bans, permit and licensing requirements, sensitive place restrictions, storage and transportation rules. Every one of those cases will now be argued through the lens of historical analogy instead of rigid historical duplication. That makes outcomes harder to predict, but also harder to manipulate. Governments will argue that historical laws restricting dangerous weapons, regulating public carry, or disarming dangerous individuals provide sufficient analogs. Gun rights advocates will argue that modern regulations go further, last longer, or burden rights more severely than anything seen in American history. Both sides will cite history, both sides will claim tradition, and courts will have to decide who is closer to the truth. The same logic doesn't stop at firearms. Free speech cases involving financial access, digital platforms, and economic pressure will increasingly hinge on whether modern suppression tactics resemble historical efforts to silence dissent indirectly. Courts will ask, did governments historically pressure intermediaries to suppress speech? Were those practices accepted or rejected? How did constitutional principles respond? If indirect suppression was historically viewed as unconstitutional, modern versions, no matter how technologically advanced, may face the same fate. This is why advocacy groups, financial institutions, and regulators are all paying close attention to this ruling. Legal theory is important, but practical protection matters more. If any part of this ruling intersects with your life, here are the steps you should take immediately. If you are involved in any family law dispute, restraining order process, or protective order hearing, understand that the outcome may affect your constitutional rights. Read every document. Look for language involving threats, danger, credible harm, or firearm restrictions. If that language appears, federal consequences may follow, even if the case feels minor. Many family law attorneys are excellent at divorce, custody, and civil procedure, but are not trained in federal firearm statutes. Ask direct questions. If firearms are involved, consult someone who understands the intersection of civil orders and federal criminal law. Anything you post online during a legal dispute can and will be used against you. Statements made in frustration are often interpreted as intent. Ambiguity is rarely resolved in your favor. Silence is safer than explanation. Civil proceedings can restrict rights just as effectively as criminal convictions, and sometimes more quietly. Never treat civil court as informal or inconsequential. If you run a firearms-related business, advocacy group, or training operation, do not rely on a single bank, do not rely on a single payment processor, document denials of service, track regulatory pressure. If multiple institutions cut ties following public government statements, consult constitutional counsel. Patterns matter. The most dangerous misconception isn't about guns or speech, it's about rights themselves. Many Americans believe constitutional rights are permanent, automatic, and self-enforcing. They're not. Rights are exercised within systems, and those systems operate on procedures, language, and interpretation. Miss a hearing, ignore paperwork, post the wrong message, assume the rules don't apply to you, and suddenly the protection you thought was automatic becomes conditional. The Supreme Court didn't weaken constitutional rights in this decision. It clarified how they survive. This ruling made one thing clear. Constitutional law is evolving in real time, and the consequences are immediate. Whether you care about firearms, free speech, financial access, or government overreach, the rules are being rewritten through court decisions, not elections, not headlines, and not social media commentary. If you wait until a courtroom is involved to learn how your rights work, you're already too late.
This decision affects how laws are written, enforced, challenged, and defended. It affects how civil proceedings spill into federal consequences, and it affects how the government can and cannot use indirect pressure to achieve outcomes it can't mandate directly. Understanding that difference isn't optional anymore. Stay informed, stay cautious, and don't learn about your rights the hard way. If this breakdown helped you understand what the headlines missed, make sure you stay connected, because the next ruling will build on this one.